lady, I have good news for the court, for a change. And that is my instructing attorney next to me has told me that at 3:30, even if I'm mid-sentence, he's going to pull me down onto my backside.
Well, it's Mr. Moster, try. I think I'll hold you to that. Okay. You may proceed.
As I was referring earlier to and I use this word with respect to the complete botch up with regard to the measurement of the time of death by Dr. Khan and Dr. Abrams, for that matter, I omitted to mention something else which was staggering in its implications, and that is that there was an admission made by Dr. Khan under oath that he had used the same methodology and reported in something in the vicinity of 50 other similar cases along the same lines and in the same manner, mutatis mutandis, and one shudders at the implications of that. But to get back to the injuries that were missed during the autopsy performed by Dr. Khan, and they're so quick to criticize Dr. Perumal, but when you analyze it, actually, if you point a finger, you must remember that 3 or 4 fingers point back at one. They missed 2 rib fractures on the right-hand side. That is Dr. Khan. He missed all the left-sided rib fractures. Why did he make this error? It's because they didn't strip the ribs properly, as is prescribed, a so-called, rather inelegant term, spare ribbing. But you have to strip away the tissue and the muscle around the ribs to be able to identify fractured ribs, particularly if there is no associated hemorrhage. And while I'm on the point of that, my learned friend yesterday tried to make something of the fact that with regard to the right rib fractures that were picked up, there was associated hemorrhage, arguing as he did that indicates that those injuries were sustained ante-mortem. In other words, I suppose, once again, that the accused beat up the deceased. That doesn't hold water for numerous reasons, one of which I will deal with when I deal with Dr. Loftus's evidence. But more importantly, the fact that there is associated hemorrhaging in the vicinity of rib fractures is not, and the evidence has shown this, and the authorities overwhelmingly, is not indicative of a ante-mortem injury to the ribs. If the CPR that is used or applied is effective enough in even establishing a minor circulation, maybe not an effective enough circulation to bring the patient back to life, but a minor circulation, then there will be associated fracturing if there's a rib, hemorrhaging if there's a rib fracture in a deceased person. But what we do see here is associated hemorrhaging on the right-hand side and none in regard to the fractures on the left-hand side. And one postulates that this is perfectly in line with the approach, once again, of Dr. Loftus. The patient was in the process of dying, but had not yet completely died. It's a process, not an event, when she was laid on her back, and when the first resuscitation was done, she was still alive with a, albeit inadequate, circulation. Later, in the course of resuscitation by Mr. Thompson on the other side, she had crossed the Rubicon. Now, let me move on. He missed a fracture of the sternum. At one stage, when this was put to him, Dr. Khan came up with a laughable suggestion that the patient must have sustained those injuries during the period between being moved from Paarl mortuary to the crematorium or whatever, the funeral parlor in Johannesburg. There was just no evidence or support for that whatsoever. It's another example of him trying to exculpate himself at the expense of other people when the stark reality is facing him like a brick wall. The next aspect where he lost the plot with respect was his evidence regarding the cause of the rib fractures. I accept that there is more than one possible cause of those rib fractures. We know she fell in the garden on a small wall. Maybe some of the fractures were caused then. But what cannot be denied, and which was completely not taken into account by either Dr. Khan or Dr. Abrams, was the fact that associated rib and sternum fractures follow, like day follows night, resuscitation by means of CPR. There is even a saying, and it's on record, that if you don't fracture a rib or two, you're not doing the CPR properly or vigorously enough. But that never entered his mind. Or he didn't want it to enter into his mind because he was focused on something completely else. He had by then blinkers on and he couldn't look left or right. The danger of a preconceived prejudgment. Next injury missed, a scar on the right knee. Next injury missed, a scar under the patient's right breast. Bruises on the left arms missed. Bruises missed on the right arms. Bruise on the left forearm missed. No underwater dissection of the thorax performed in this case, which is what you would have needed to do to check whether a pneumothorax was present or not. That wasn't done. The opening incisional cut to the top of the sternum and above was not done according to the prescriptions in the ABC of forensic medicine. The removal of the brain was done at the wrong time. A hemorrhage into the tongue was missed. And incidentally, while I'm on that point, it is instructive when one is looking at the authenticity of these handwritten notes of Dr. Khan, that it emerged during my cross-examination of him that the order in which he wrote the notes of things and findings here differed considerably and completely from the order in which he performed the tasks that he was describing here and made the findings. Now, I don't know, but if I'm writing on a blank piece of paper and I do things in a certain order, I don't write 3 lines and then leave a gap of 6 inches and then write something more and then come back and write something in the middle of that gap. That just doesn't make for probability sense. Right. Now, let's look at the pallor. The diagnosis is made on the strength of pallor to the tip of the nose and pallor of the lips and one tooth mark on the inside of the lower lip, to the effect that this patient was smothered. One got the impression that this is one of Dr. Abrams's hobby horses, smothering. However, the evidence was that the presence or absence of pallor is not diagnostic of smothering. You can get smothering with no pallor, and you can get pallor with no smothering. It means nothing. What is more important is if you look at the progression of events. The patient is examined, the deceased, is examined on the floor of the bathroom, and written notes are made allegedly contemporaneously, and no pallor is reflected at all. Then a note emerges in the incident scene report where it is stated that she had pallor on the tip of her nose. Then 4 days later, or 3 days later, when the post-mortem is performed, it says she has pallor on her lips and the tip of her nose. And that pallor on the lips and the tip of the nose is used to constitute proof of smothering. And with respect, as pointed out by Dr. Perumal, that is not forensic science. That is mumbo jumbo, for two reasons. Number one, clearly the pallor at the tip of her nose, if there was such pallor, and the later evolution of pallor on her lips was associated with the process of lividity or hypostasis. As she lay for longer and longer periods on her back, the blood drained out of the highest extremities on her anterior aspect, and so you would expect pallor.
So would every deceased person have pallor then?
Well, every
Surely
deceased...
this is something that they would see in every deceased person.
And it's something one regularly sees, my lady. But the proof of the pudding, according to Dr. Perumal, in his experience, and according to standard authorities, and confirmed by Dr. Loftus, was if you want to exclude or diagnose smothering, you've got to do a so-called facial flap dissection. And that wasn't done by Dr. Khan, it wasn't done by Dr. Abrams, and it was done by Dr. Perumal in the second autopsy, and it excluded smothering. And with regard to the tooth mark on the inside of the cheek, or the lip, a standard observation made in all cases involving mouth-to-mouth respiration and CPR. So there's nothing in that smothering, nothing whatsoever. But that is the mainstay of my learned friend's case. That's what he presents to you. Now, the technique of having to perform a facial flap dissection, Dr. Khan and Dr. Abrams couldn't explain why they didn't do it. One of the problems with Dr. Abrams was whenever one put anything to her, whether it was an authority or a proposition, she trotted out the same old mantra. She was clearly manually strangled, and there was no need to do any further investigations. That was the sort of essence of her evidence. It was so obvious. Well, actually, it wasn't so obvious. Now, there was also a serious misinterpretation on Dr. Khan's part, and I like to believe that this was exacerbated by the imagination, let me be generous, of Dr. Abrams with regard to the nature and cause of the lung contusions. And there we had the ultimate expert testifying. He took us through those injuries, the location of those injuries, at the fold of the lung, of the lobe of the lung. Dr. Loftus took us through everything. You'll recall that the essence of Dr. Abrams's evidence, which, with respect, she sucked out of her thumb, was that because of her lung injury, this deceased was so debilitated, her level of mobility was so severe that she wouldn't have been able to ward off a smothering. That was really the essence of what she said. You know, she was barely alive from that assault which caused a lung injury. Well, Dr. Loftus put pay to that. He took us through. Remember, he has the benefit of being a specialist anatomical pathologist, in other words, a histopathologist, as well as a specialist forensic pathologist with impeccable experience and qualifications, both for the state and in private. Dr. Loftus showed us how if there were to have been a serious lung injury along the lines hypothetically postulated by Dr. Abrams, then the lung would have had to have a so-called leopard skin-like appearance, and that was absolutely missing on all his examinations of all the photographs. Remember, as a specialist histopathologist, day in and day out, he is practiced at studying photographs, studying slides, studying tissues, studying things microscopically, examining things macroscopically. That is one of his fields of particular expertise. He says there's no merit whatsoever in the allegation that this was a serious lung injury that debilitated her in any measure whatsoever. Now, I want to just, I have to unfortunately quote the language, but I just want to postulate the following possibility. What person, injured as Dr. Abrams would postulate, to the point of being unable to ward off a murderous attack, what person is going to sit up in her bed at 7 in the morning and say, excuse my French, I've cut my fucking toe? Doesn't work like that. That person, according to Dr. Loftus, if she is coughing up blood and swallowing it, as Dr. Abrams would have us believe, there would be signs of that in the photography of the lungs, and there was nothing. Number two, there was nothing on histology picked up by Dr. Perumal.
Sorry to interrupt you there, but I think that answer by Dr. Abrams was in response to the scenario at the time painted that she could possibly have injured her ribs, having fallen outside before returning to the bedroom. And it's on that basis that I think I asked Dr. Abrams whether that scenario would be what her capacity would be, had that been the case. Because that is what I think Mr. Mialik at the time had suggested.
No, we certainly cannot exclude the possibility that she fractured one or more of her right ribs when she fell in the garden on that little wall. That's not to be denied at all. And not that that's an assault on the part of my client, but the $60,000 question is, was her condition that morning, taking into account what we now see of her lungs, even now, was the condition such as described by Dr. Abrams, namely a pathetic specimen who was unable to fend for herself? And Dr. Loftus put pay to that 100% totally and utterly. There's just no support for that whatsoever. He also said that the overwhelming likelihood is that, as I understand his evidence, that those rib fractures were not sustained by a fall in the garden, that they were sustained by, or as a direct result of the failed resuscitation attempts involving CPR. Now, moving on.
So I don't understand now. Is it your case that there was no way that you could have fractured her ribs in the fall outside, and that it was all according to Dr. Loftus in the bathroom during resuscitation? Because that theory was raised by your predecessor as a possibility to consider.
It remains one. As I stand here, I'm not excluding that possibility. There are various possibilities. The two ones that seem to stick out the most are that she sustained a fracture to the right-hand side when she fell in the garden, and the other one is that it was a resuscitation artifact.
So if I understand correctly, your suggestion is that there's a possibility that she had fractured herself outside, and with that fracture went about later and executed her hanging.
I cannot exclude that possibility.
Thank you. Sorry, I just wanted to make sure I understand that.
Can't exclude that possibility. But what I can say is I can exclude the testimony or opinion of Dr. Abrams to the effect that after sustaining that fracture, she would have been so debilitated and her lungs were so badly injured that she couldn't fend for herself. That has been blown out of the window by Dr. Lox's evidence. It's not the case. And he also drew our attention to that authority in Knight, which referred to the flight or fight process, and he mentioned how the presence of adrenaline can play an enormous role in masking pain even from severe injuries.
I think he made reference to a soldier on a battlefield, and that experts should not adopt a dogmatic approach when they speak of the abilities of someone so injured.
Absolutely.
Okay, I've got that. You can move on.
I think. Okay, let me go further. The key issue, if you want to boil it down with regard to the post-mortem findings, is was the deceased manually strangled or smothered, or did she hang herself either intentionally or accidentally? And Dr. Khan came to that conclusion based on about 5 or 6 reasons. I've taken his evidence together and I want to deal with every single reason upon which he based that opinion, but I'm going to deal with it briefly. The first one was his incorrect conclusion relating to lividity and hypostasis. I've dealt with that. The second one was the extreme bruising that he found on her thighs. It was another factor that he took into account. It is now common cause, number one, that she sustained those injuries through a fall that she had about a week before her death in the gym or wherever she was training, and fell on some dumbbells. She reported that to her mother. She reported that, who saw those bruises, she reported it to her sister. And what is more, Dr. Khan admitted that there were no other injuries on the patient that one would normally associate with a battered wife syndrome, such as bruises, cuts, scrapes, abrasions, etc., in different stages of healing. There was nothing like that. The next thing that he based his decision on was an estimation of the time of death, and that's out of the window. As I pointed out, because of the failure on his part to elicit all the necessary information at his inspection, even the time up to 8:28 is fraught with uncertainty. And Dr. Loftus, in one of his slideshows, demonstrated how a small change, for example, in temperature of a degree or so, could make a huge difference to the time of death parameters. Dr. Khan based his decision on the fractures to the ribs, and I've dealt with that. He based his decision on the blood spatters on the duvet, the pillows, and the bathroom floor. But if you look at the evidence of Captain Hubert, and he seemed to me to be a credible witness, his interpretation was, number one, that he couldn't exactly say when the blood spatters were deposited. Number two, the amount of blood that he observed was consistent with normal day-to-day living, and could even be, in the case of the deceased, the accused, associated with a bleed that he was not even aware or conscious of. So small and infinitesimal was. The upshot of Captain Hubert's testimony was that the blood spatter evidence did not in any way whatsoever contribute towards proving the guilt of the accused. If anything, as such, it was exculpatory. The other thing that Dr. Khan took into account were the couple of cuts and bruises and abrasions that he did pick up on the deceased. He also made an error with regard to the abrasion on the left eyebrow and the hematoma on the eyelid. He didn't realize that what had happened there was that the blood had tracked down from the abrasion subcutaneously, and he made that conclusion without having any idea whatsoever of the version of events of the accused regarding that evening, and it came to him as quite a surprise, and there was a definite shift in his attitude when the version was put to him by me. The next thing that he took into account was the location of the injuries to the neck. He didn't know or wasn't aware of the fact that you get injuries to the neck with ligature hanging because of the convulsions that take place in the agonal period. It's well known. In hangings, the injuries in the neck are not limited to the immediate anatomical and geographical area adjacent to the ligature mark. They can be anywhere in the neck, and the authorities are on record. Dr. Perumal dealt with that. He also concluded that there had not been a hanging because he said the ligature mark was not circumferential, there was nothing on the back of the neck. Well, with respect, I've dealt with that. He then said, and this is quite important, that one of the reasons why he excluded hanging was that the ligature mark did not have a leathery or parchment-like appearance. Dr. Loftus, who's the expert histopathologist, came in here and with reference to the slides taken by the official police photographer at the scene of the alleged crime, pointed out the marks and pointed out where it did have a leather-like and parchment appearance. And not just that, Dr. Perumal produced authority to show that you usually associate a leather or parchment-like appearance when a rough material used as the ligature, like a rough material like a rope or string or something like that. And he showed a specific authority, which is on record, that with a smooth material, ligature material like an electric cord, you don't always get a leathery or parchment-like appearance. So either way, there's no basis for that conclusion. But the fact of the matter is that Dr. Loftus specifically drew our attention to that, and remember, his evidence was not challenged. And when he was asked about this, whether these marks could have been, whether this ligature could have been placed ante-mortem or post-mortem, he said that with a 95% certainty, he can state that it was placed ante-mortem, before death. And that really should be the end of the matter. But let's go further. Dr. Khan came to some other conclusion and then appears to have changed it. I don't know what happened. But obviously, initially, he concluded that there was a fracture of the hyoid bone and later changed it in his report. And he later said, although this wasn't in his original notes, that there was a fracture of the horn. I think it was the left horn, doesn't really matter, of the thyroid cartilage. And he gloated about the fact that this had been missed by Dr. Perumal, such an obvious injury. But when the truth really emerged, what he was looking at and mistakenly interpreting as a fracture of the horn of the thyroid cartilage had not been missed by Dr. Perumal. Dr. Perumal had taken 4 photographs of that supposed fracture, but he had concluded that it was a dissection artifact. In other words, that it had occurred when Dr. Khan had done the dissection. Dr. Loftus explained how it happened. You've got to dissect if you suspect a fracture, or if you see something that looks like a possible hemorrhage and you suspect a fracture. You've got to dissect along a certain plane. You don't dissect across the plane of that fracture. And that's exactly what Dr. Khan did. He dissected in the wrong plane, and he cut off the tip of the... Of course he won't admit that. It's embarrassing. But that's why Dr. Perumal photographed it, kept a record of what he saw, but didn't write it up as an autopsy finding, because he knew that it was a so-called iatrogenic autopsy artifact. It was caused by the doctor. The other factors that Dr. Khan took into account in deciding that there was no hanging here was occipital hemorrhages, and he confused that with autopsy dissection artifacts. I've dealt with a pallor of the tip of the nose and the lips. And the next thing is Dr. Loftus clearly demonstrated to us, he devoted a whole slideshow to us to show the sign in the adjacent, just below, inferior to the ligature mark, the vital reaction. Now, you don't get a vital reaction like that if you apply the ligature to a deceased person's neck. It has to be applied ante-mortem to get that vital reaction. I don't know whether Dr. Khan ever looked at the photographs that were taken at the scene of the incident. Dr. Loftus seemed to feel that they were superior to the ones taken at the post-mortem. But in any event, clearly Dr. Khan missed that. He misinterpreted the neck injuries, the rib fractures, the sternum fractures, the lung injuries. In fairness to him, until I cross-examined Dr. Khan, he was unaware of the dribble of saliva that the accused had found in the left corner of the mouth. Now, what is the significance of the dribble of saliva? The accused testified about that, it previously having been put by me in cross-examination to Dr. Khan, and it was never disputed in cross-examination of the accused. Dr. Perumal produced the authorities that demonstrated that the presence of saliva in a dead person where the ligature has been removed is virtually diagnostic of an ante-mortem hanging. The authorities are on record. Lastly, Dr. Khan reached his decision without having any version of events from the side of the accused as to what happened, despite there being no other evidence. And I'll get to it in due course, but despite the accused being happy and willing to fly down to Cape Town and give a demonstration to the police at Spuy of exactly what events occurred that evening. And then lastly, and significantly, whereas Dr. Loftus was able to pick up the presence of probable urine stains on the floor of the bathroom underneath the deceased in the vicinity of her lower abdomen or buttocks, Dr. Khan seems to have missed that, or certainly the implications of that entirely. And of course the implications of that are that when the moment of death finally comes and the relevant sphincter muscles relax, you will get a leaking of urine and extravasation of feces. And that is what was found there. No. Just getting back to the fracture of the thyroid cartilage, it's worth mentioning the undisputed evidence of Dr. Perumal that actually the presence or absence of a fracture of the horn of the thyroid cartilage is neither there nor there, neither here nor there. Because as Dr. Perumal said, it can never be used as proof of a manual strangulation, because a fracture of the thyroid cartilage horn is the most common musculoskeletal injury found in cases of hanging, by suicide by hanging. I noticed with interest that during the course of cross-examination of the accused, some huge bundles of sketches and diagrams and postulated scenarios were produced by my learned friend for the first time with marginal benefit, or without achieving any results, and these were put to the accused. Also, another bundle was put to Dr. Perumal. I must just emphasize the following. None of those bundles had been introduced or proved in the appropriate manner through an appropriate expert witness, such as, for example, Dr. Khan or Dr. Abrams, or maybe a forensic scientist, to lay a basis to explain what they meant. They have no value whatsoever in the context of this case. They might have been introduced as exhibits on the basis that the court would later consider them. My appeal to the court is that they should be totally and utterly ignored. So, to cut a long story short, on every single level, bias, expertise, inexperience, incorrect conclusions, and competent performance of the autopsy. Unfortunately, Dr. Khan did not get out of the starting blocks. Which doesn't really say very much for Dr. Abrams in terms of a supposed supervisory role. One can excuse errors and faults made through inexperience and ignorance and so on the part of Dr. Khan. The worrying thing is that if not challenged, that incident report and that post-mortem report could well have been accepted without criticism or argument. And where would my client then have been? I'm not going to deal at any length with Dr. Abrams. I just want to make 2 or 3 comments, and I say them with great respect, but her evidence as an expert was a pitiful exhibition. It speaks for itself. It's interesting that she didn't, in the beginning, even know how involved she was, and whether she was busy at the same time with another post-mortem or not. She changed her evidence right in the beginning in that regard. It's also interesting to note that she didn't make a single scrap of paper. Not one solitary note did she make. The authorities were put to her. It's your bounden duty, both professionally and in terms of recognized forensic medical practice, to keep proper and accurate notes. She didn't keep a single thing. The first that emerged from her was an affidavit a few days before the trial started, which really amounted to two things: a regurgitation of a few of the salient points arising from Dr. Khan's autopsy report on the one hand, and a vigorous attack on the integrity of Dr. Perumal on the other hand. Now, without for a moment underestimating the unacceptability of such an approach in attacking a fellow professional who she effectively called a hired gun. What she said was, Dr. Perumal gets paid to do his job by the defense, and therefore you can't believe a word he said. He's a hired gun. If that were the approach, incidentally, adopted by our courts, there wouldn't be an expert available in any litigation. Number two, ironically, Dr. Abrams seemed to have lost sight of the fact that she, as a supposed expert, is paid by the state for whom she's testifying. But more importantly, apart from the fact that in doing that she acted in violation of her professional code, there was no merit in her criticism there. You remember she testified that the only people who should be doing these forensic autopsies are government employees. So little does she know of her own profession and the personalities and people in her profession that she seems to have been totally unaware of the fact that Dr. Perumal is and was at relevant times the chief government forensic pathologist for the Mpumalanga province. So he's the very type of person who she says should be doing this sort of thing. I think that her evidence can be discounted in its entirety. It's meaningless, and it was frightening to see that a person in such a senior position, a supposed specialist and expert, falling so far short of the standard and norm required of experts, namely that their opinions should be based on knowledge, experience, competence, and should reflect sound logical reasoning and be based on justifiable and accepted scientific principles. That just didn't exist with Dr. Abrams. I want to give just one example of that. Against the background of the authorities that had been placed before Dr. Khan, pointing out how he had gone completely wrong with the calculation of the time after death. Against that background, and him acknowledging that and admitting that he had made the same mistake, mutatis mutandis, in 50 other cases, the mind boggles again. Against that background, Dr. Abrams still wanted to argue about it. The authorities were placed in front of her, and she would not budge. One of the signs of a true expert is to acknowledge that everyone makes mistakes, and when you make a mistake, you acknowledge the mistake and you move on. you adjust your opinion. That's not. She is the archetype adamant. And in the process, justice fails, or there's a risk. Now, lastly, I don't know if I emphasized this enough. I pointed out to Dr. Abrams that this was a classic case where histology should be done, in my view and in the view of Dr. Loftus. If histology had been done at an early stage of a portion of the ligature mark, a microscopic view of tissue reaction could have been seen, and it would have been able to be shown on a microscopic level whether or not there was a vital reaction. As the authorities point out, even when a ligature is applied ante-mortem, you don't always get a vital reaction. So the absence of signs of one doesn't exclude hanging, but the presence diagnoses hanging ante-mortem. No, he was clearly manually strangled, and there was no need to perform any other tests, even if they might just possibly assist the accused. So, against that background, we have to compare the presentation of Dr. Perumal and Dr. Loftus. And it is my respectful submission that there is no way under the sun that the forensic pathology evidence of Dr. Khan, with or without Dr. Abrams, can possibly be preferred to that of Dr. Perumal. He was attacked in writing. His integrity and attacks on him in terms of cases where he'd been involved in the past was actually the main thrust of my learned friend's cross-examination. There was very little about forensic pathology. Character assassination is, I suppose, a tool that can be used. But I thought that Dr. Perumal managed it with dignity and professionalism and came out on top. I thought he testified in a measured and reasoned manner, and he was reasonable as an expert. And what did he essentially say? That in his view, the most probable cause of death in this case was ligature strangulation. In other words, the patient hanged herself, that the ligature was applied in life, and that all the injuries that he came across were consistent with that finding. He said that the saliva trickle was an important consideration in view of the authorities, but not the only one. He said, in medicine, nothing is impossible. He cannot 100% rule out other possible causes of death, such as manual strangulation. But the overwhelming probability is the one that he supported. His evidence was confirmed by his report. It was supported by his histology, although he did not do histology of the ligature mark. Unfortunately, no one asked him why he didn't, and there might have been a good reason for that. He wasn't challenged on that. I found him to be a very reasonable witness. He readily accepted that there have been cases where his views have not been accepted by the court. There have been cases where he has made mistakes, and he has erred. I think what he essentially was saying is, show me the doctor who hasn't. But that's not the point. In this case, he was of the view that it was overwhelmingly probable. that the patient hanged herself, that the injuries to her neck were caused by an ante-mortem application of the ligature. And as long as that, from a legal point of view, as long as that possibility, it is even as low as this, as long as that possibility cannot be excluded, there has to be an acquittal. Where it's probable, or more probable than manual strangulation, well, then there's no issue. The man is innocent. The same applies, but even more so, and more overwhelmingly so, to the testimony of Dr. Loftus. A consideration of his curriculum vitae and the evidence that he gave in that regard demonstrates amply that in him we're dealing with an expert on the level of pardon me, if I could just on the top level. Just want to find his testimony. In this regard to the exhibits, that's why I'm confused. To the exhibits commencing with AA, and carrying on to JJJ. My lady, is it possible for me to request a 5-minute comfort break? For some reason or other, my legs seem to be giving in underneath me. Sorry about that, but if I could just sit for a few minutes.
Mr. Master, I'm keeping it to it. Are we good for time?
Plus 5 minutes, my lady.
Thank you. Let's jump.
Thank you, my lady. I don't intend to pause for long in dealing with the evidence of Dr. Loftus. I believe it speaks for itself, and I've already spoken frequently about the quality of his testimony, the fact that he was not challenged on any material respect, and the gravitas of his opinions. If ever there were a case of opinions based on sound logical reasoning with a firm scientific background, then that applies to him. Just highlighting a few aspects that arose from his testimony. His conclusion was 95% certainty. In other words, certain that the deceased hanged herself, and that the injuries to her neck, and in particular the ligature mark, was caused ante-mortem. If we look at Exhibit BB, which really starts with a document prepared by Dr. Loftus entitled Junior Doctor, and sets out the spectrum of pathology. I would like to just take the court to one authority that's attached here on page 12. It's also a duplication of Exhibit M1, and essentially it says the following. This is just an aid memoir. A mark of saliva dribble is a classic feature of ante-mortem hanging, but it may not always be present in all cases. In other words, if it's there, the hanging was ante-mortem. If it's not there, it doesn't mean the hanging wasn't ante-mortem. And then on page 18, emission of semen and of saliva may be due to stimulation of the autonomic nervous system. If this is the case, then it can be taken that the emission occurred ante-mortem. I really need to say no more. In Exhibit CCC, Dr. Loftus dealt extensively with lung injuries, and he expounded the clinico-pathological correlation. And he summarized it as set out on page 15. No signs of aspiration of blood are evident on the surface of the lungs. PM findings, postmortem findings as per paragraph 12 and 13 of postmortem report by Dr. Khan. Blood-stained fluid was present in the trachea and the main bronchi. No signs of hemorrhage other than a contusion, and petechial hemorrhages were noted. Histology only showed congestion and pulmonary edema. The presence of blood in the air spaces was not recorded. No morphological findings to indicate that respiratory function was compromised preceding the death. There you have it. That's the end of Dr. Abrams. With regard to the ligature of the neck, I've dealt with his evidence already, and that's Exhibit DD, and he deals there with his observations of the vital reaction on the photographs and the slides that were presented to him. It is quite clear. Then under post-mortem dissection of the neck, he dealt with this at length under EE. One of the points that he wanted to bring across was how difficult it is for an inexperienced person to have a three-dimensional concept of anatomical structures by means of a two-dimensional photograph. And that when skin is reflected back, in other words, if the facial skin is reflected back so that everything's upside down, it's even more difficult. and one must avoid the pitfall of falling into the trap of drawing conclusions on the basis of incorrectly interpreted slides, photographs, and images. A classic case was the malalignment of the shoulders of the patient, of the deceased, when photographs were taken. I like to think of it this way. As I understand the position, if I were to take a little dab of Vaseline and put it on my arm, and with that dab of Vaseline attach a screw to the outside of my arm, and an X-ray were to be taken from the frontal aspect, it would look like that screw is on the same level as the bones in my arm, yet it's on the outside of the skin surface, because you don't have the benefit of a view from the side as well. And that's the type of concept which is so difficult for lay people to understand. For me, very difficult. And what he was saying was, actually, when you took all these distortions and reflections into account, the injuries that were found in the neck were perfectly consistent with a ligature hanging and weren't so far removed as Dr. Abrams, in her mistaken approach, would try and have us believe. And then lastly, although there were peripheral aspects that Dr. Loftus dealt with, he gave us the correct approach to the calculation of the period of death in Exhibit FFF. Now, certain very limited cross-examination was put to Dr. Loftus. It was pointed out that the authorities that were put to him had been edited, with relevant portions excluded from the edited bit, and then he was put 3 references to so-called pseudo-strangulation marks, and he was asked to produce the actual documents or journal entries. 2 of them couldn't be produced at the time, and the other one, when seen in its entire context, was interpreted quite differently. That was the article by Spitz and Fisher. So essentially we have the unchallenged evidence of Dr. Loftus, which says this woman, she hanged herself with a 95% probability, that the injuries that he observes and sees are 100% consistent with the ante-mortem application of the hanging ligature material, and that the theory that she was debilitated by severe lung injuries does not hold water at all. There is nothing to prove or substantiate that. Now, if I may turn to the next item on the agenda, and I want to do this as briefly as possible, and that is the factual scenario against the accused. My lady, time is not on my side, and I'm going to refer you to paragraph 3 of my heads. But I do want to postulate some possibilities in this regard that will also make my treatment of Dr. Daniels' evidence and the version of the accused shorter and easier in due course. What the state alleges is that having murdered his wife, the accused manhandled her into the bathroom, from the bedroom. I might just add, whether he dragged her or carried her or manhandled her, I don't really know what the state suggests. But he seems to have been able to do that without any discernible sign in terms of DNA evidence, blood, abrasions, carpet fibers on her body, etc., etc., etc. But anyway, he gets her now into the bathroom, the dead body. And I must just add, all of this is surmise on the part of the state, deduced from the fact that she was found in the bathroom, because there's no evidence to indicate how practical or feasible it might have been for him, without any trace, to move what effectively amounted to a dead weight of 52 kilograms. And I understand that carrying or lifting or maneuvering a dead weight like that is a massive task. Whether a person of his stature, height, etc., is able to do that without a trace is a good question. But now he's got her in the bathroom. The question arises, of course, as to the following. When did he murder her? At what time, in other words? And when did he get her in the bathroom? Did he murder her at 2:40? Did he murder her at 5:40? Did he murder her at 7:40? When did he get her into the bathroom? What happened between his murdering her and getting her into the bathroom? But now, the state's case, and this is in the substantial statement of fact, it is an integral part of the state's case, is that he placed one part of the cord of the deceased's electric hair iron loosely around her neck and another part in a single strand around the left-hand outer hook on the inside of the bathroom door. Of course, it raises immediately the question as to why does the state say he placed the cord loosely around her neck? Why does it use the word loosely? Of course, it uses the word loosely because it has to try and remain consistent with Dr. Daniels' later evidence. Remember, the state all along the line has said its two crucial witnesses are Dr. Khan and Dr. Daniels. Mr. Daniels, pardon me.
Did I understand Dr. Perelman's evidence to be that, from his understanding, the ligature would also have to have been loose around her neck?
Would also have to be?
Had to have been loose around her neck. Not tight.
Not tight in the sense of the entire thing looped around the neck, because then he would have seen a circumferential line, but it could have been tight on the one side and upward pointing with an inverted V on the other side, and that is actually the scenario that Dr. Perelman postulated as having happened here, with the knot somewhere along the cord. But while I'm about it, and I thank the court for reminding me, it was also Dr. Perelman's testimony that the demonstration of how the cord was around the neck as supplied by Mr. Daniels was impossible. He rejected that it was not possible. It was not reconcilable with what he saw on the neck, which is, of course, a massive blow to the credibility or reliability of Mr. Daniels. Now, what happens next The accused has now formed this intention to simulate a suicide, to hide his murder. He wants to conceal his murder. So he's now in the bathroom with his wife, his deceased wife, with the wire loosely around her neck. And the question is, how does he do that? How do you hold up a dead body and loop a cord around the dead body's neck and hang the cord around a hook? There's no evidence to show that that is possible. And one imagine if it was possible, and if the cord was so loose, then why did he ask for Mr. Daniels' help to take off the cord at a later stage? But in any event, the logistics of this whole thing postulated by the state baffle me. Because then he had to get out of the bathroom to lock it from the outside, the accused. He's now linked his wife's neck via a single cord to the hook. He's now got to get out of the bathroom. Now, with the best will of the world, he has to have a certain amount of space. The door has to be open a certain amount for him to be able to get out, to get his body through. And now, let's just imagine that he closes the door. Forget about locking it for a moment. He closes the door. We know that when the door was ultimately opened, we know as a fact that it could only be opened 150 millimeters. That's 6 inches.
How do we know that as a fact?
Because Mr. Daniels has testified to that and he demonstrated that.
Mr. Daniels said he opened it 15 centimeters because he stopped, not because he couldn't open it any further. He stopped. Now hold on. He stopped.
Okay. But here we have a difference in any event in the evidence between the accused and Mr. Daniels, because the accused says he opened the door.
So now I was talking.
Sorry?
I was talking. And you interrupted me talking.
Oh no, I'm sorry, I thought my lady had finished.
I'm saying it's not a fact. That's what I'm trying to make. It's a fact that the court has to find. It's not a fact. Please
Well,
go.
let me put it this way. The testimony of Mr. Rohde is that he opened the door, and it could only open a minute way because the body of the deceased was on the inside. It was wedged against the door. It was preventing the door from opening further. Now the question arises, how does the body get up against the door from the inside if it's only linked to the door via the wire, the cord rather, and it's closed on the outside? How does the body get against the door? The point is, no forensic pathologist, no engineer, no forensic scientist, no person in another field of expertise has come along to explain that that is possible. And I submit to the court that if I attach the deceased by her neck to the hook, even if I make that line tight, and I close the door from an open enough position for me to be able to get out of the room, and I close it from the outside, the body is not going to pull up against the door. It doesn't work like that. And in any event, it's not for the accused to prove that it doesn't work like that. The state should have proven that it does. Especially if, after all that has happened, the wire is still loose around the neck, as alleged by Mr. Daniels. How can a force be exerted via a loose wire? The whole scenario doesn't make sense. And now I just want to pause for a moment and go to the evidence of Colonel Poolman. The court mentioned twice yesterday that Colonel Poolman established that the door could be locked and unlocked from the outside using a coin or a key or whatever, teaspoon. But I just want to point out with respect 3 things. The first one is the fact that something is possible doesn't mean it happened. The fact that it was possible maybe to lock a door from the outside doesn't mean that Mr. Rohde, the accused, knew that that could have happened. My learned friend has had to argue that, he travels from hotel to hotel, he's a well-traveled man, he must know that you can unlock hotel bathroom doors from the outside using a coin. Well, my lady, I perhaps don't travel as much as everybody else, but I have never known that. Why should one know that if one is not a mechanic or an engineer or somebody along those lines? You can't assume that knowledge on the part of the accused. His testimony is that he didn't know that. Later he saw a groove there into which the screwdriver was inserted, but until that moment when Mr. Daniels inserted the blade of the screwdriver, that looked to him like the top of a screw. And then the state has yet to prove that Mr. Rohde, the accused, did in fact close the door and lock it from the outside. There's no evidence to that effect. It's an inference which the state wants to draw from the circumstantial evidence that is available. Now, the state has a duty to prove things beyond reasonable doubt. And it might have proved, and all that it has proved in that regard, in actual fact, is that in the normal course of events, if you have a coin or a teaspoon or something like that, if you have that, you can lock the door from the outside and unlock it. That's all the state has proved. It hasn't proved that you can lock it if there's weight or force on the inside hook. And it has to prove that. Because if it can't exclude that possibility, namely that if there's a weight on the inside, hanging on the inside, the door will warp slightly, preventing it being locked from the outside. If it can't exclude that possibility, that's a game changer. And let's look at the only evidence in this regard that we have on record, and that is the evidence of Colonel Poolman. And while I'm busy with Colonel Poolman, as an engineer, I have no fault with his expertise. He's not a forensic pathologist, he's not a forensic scientist, he is not in a position to make deductions or to give expert testimony on how a neck should look after a hanging. If he wants to come and say, as an engineer, I know that the first law of Isaac Newton is that for every action there's an equal and opposite reaction, I have no problem with that. But that's a far cry from what my learned friend tried to elicit through him. But now, dealing with Poolman, in cross-examination, I first of all dealt with the crack in the edge of the door, and it seems to be pretty obvious that that crack could have arisen from when the accused kicked or tried to bang the door open when he found that it was locked and started to panic. But then, from page 2000 onwards, I deal with Mr. Poorman with the business of the locking mechanism on a door like that. And it really comprises the normal latch that works with the handle, and then on the inside a locking mechanism that you can turn by hand, and on the outside a locking mechanism that is hardly visible, but you can theoretically use a screwdriver or something to turn it. But it's obviously not intended for day-to-day use. And on that point, that Mr. Rohde should have known you can use a coin or a teaspoon, Mr. Daniels, the handyman at Spuy, he didn't know that until he was taught that by his superintendent. That's his own evidence. He had to be taught that. But let me carry on with Colonel Pullman's evidence. I dealt with him at length with the tolerances involved, and they could be millimeters. So that, in other words, if a door like that is even slightly warped, it could affect the tolerances and the locking mechanism would no longer work. It's one thing to push the door from the inside and turn the inside lock. It's a different thing to lock it from the outside. Now, right at the end of this passage of evidence, I say to him the following.
So you can lock it from the outside then? Sorry, you can unlock it but not lock it.
Oh, I've got no problem.
From the outside?
Yeah, I've got no problem with unlocking because the tolerances don't enter into it. The bolt is not going to, because of the warpedness, strike against the, hit against the strike plate. But I wanted to take the learned court to this specific portion. I say on page 2007 at the bottom, line 25 of the record, to Mr. Colonel Pullman, I say the following to him. Okay, can I ask you another question regarding the locking and unlocking of the lock mechanism from the outside? Did you do that test with any weights hanging on the back of the door? And his answer is, no, my lady. And then I'm not going to read his full answer as to why he didn't do that. I'll go to line 12. Now, a weight behind the door could adjust the door in terms of, could have an effect on the door in terms of warping it, not so. He says it could. And then I said to him, and that could affect the tolerances in terms of the strike plate and the locking mechanism, as I had already dealt with. My lady, it could. I'm not sure. I did not test it. So we have no proof that if there's a weight on the back of the door, you can lock from the outside. There's a gap in the state's case. Now, having said that, I want to deal with, or go back to the logistics of this whole process. And ask once again, how do you hang a dead weight person from a hook like that? Whether you use a single cord or a double cord is of secondary concern. How do you do it logistically? We've had no demonstration to show that it's possible. 52 kilograms is a substantial weight. Now you have to lift that up, support it.
But Mr. Van Spuy, that is not the state's version. That's your client's version. The state's saying the body was laying flat on the floor.
The problem is with that version is the state has no evidence to prove that.
I'll decide that.
It's purely speculative. Because the only witness who said that was Mr. Daniels. And I'm going to get to his evidence, but his initial affidavit, and this is one of many major material blemishes in his testimony, he said he opened the door and he could see the lady lying flat on her back. He later recanted that evidence and he admitted he couldn't see her lying flat on the back. At a later stage, he says all he could see was a small little portion of her legs through the crack of the door that it would open. There is no evidence that she was flat on her back, other than the incorrect affidavit of Mr. Daniels. It's not my client's version that he supported her and put the wire around her neck and hung her on the hook. It is the state's version that he simulated a suicide.
By putting her flat on the floor.
Oh, my lady, if he put her flat on the floor with the greatest respect, with a loose cord around her neck, where does the ligature mark come from?
Well, that's what they said in the ligature. It would have been staged.
Well,
all the body was hanging. I'm attacking these versions because you are saying that the state haven't proven how you can hold up a dead person and then simulate hanging. So I'm testing that.
Right, my lady, really. The state doesn't know what its version is. That's the problem. If I could just take this whole thing one stage further. If he's able to simulate a hanging and to lift her up and bodily carry her through to the bathroom, why on earth, I ask myself, would he need assistance in removing a loose cord from around her neck? A tight cord, yes, but a loose cord. Why?
The state is saying that he did that so that there could be an alibi.
The state is not saying that, as I understand it. It has never used the word alibi, to my knowledge. But the state is saying that he did that, but I'm saying, why on earth would he do that? It doesn't make sense. But I think the time has come for me to just place on record items of evidence that are common cause in this case. And I want to submit that the logistics involved in the version of the state do not hold water. And that in any event the state fails in proving a case when a comparison stands to be drawn between the version of the accused and that of Mr. Daniels. And I want to emphasize, the state has to prove that the door with a weight on the inside was capable of being locked from the outside with a key or a spoon or whatever. It has not proved that. The state has to prove that Mr. Rohde was aware of that possibility. It has not proved that. The state has to prove that he wasn't just aware, that he did it using some or other implement. The state has not proved that, and it hasn't produced an implement that was used. It has speculated about keys, teaspoons, coins. No implement has been produced. It cannot infer knowledge on his part, as it is trying desperately to do in my learned friend's argument, for the simple reason that to infer knowledge on his part is not a possible thing to do. The average man in the street does not know that you use a coin to open the bathroom door from the outside in the average hotel room. And in any event, who says you can? Who says it's not only Spuy or that it's all hotels? There's no evidence to that effect. And lastly, if the handyman himself has to be taught that and doesn't know that from personal knowledge, how on earth can you expect a guest to know that? Now, I've got really 3 more issues to deal with in this matter, and I've lost a bit of track of time of things, my lady. Did the court say we were going to break? Because I need a break with respect. Irrespective of the 3:30 deadline, I need a break. I cannot just carry on talking and talking since 9:30 without. May I request that we break for 20 minutes or half an hour?
Thank you. 20 minutes. Thank you.
As the court pleases.